Greetings and welcome to this week's edition of Smart Counsel for Lunch. I'm Suzanne Sayward, a partner at the Dedham, Massachusetts law firm of Samuel, Sayward, and Baylor, where we concentrate our practice in the areas of estate planning, elder law, estate and trust administration, and probate. Well, most people consider it a great honor to be named as the personal representative or trustee of someone's trust. And while I agree with that, I want to emphasize that it's also a great responsibility that requires a lot of time in most cases. The tasks involved in settling an estate or administering a trust include dealing with the lawyers and the accountants and the financial people, going to the banks, marshaling all the assets, preparing and filing the tax returns, both income tax returns and sometimes estate tax returns. And of course, dealing with the beneficiaries in a fair way and keeping them informed of the progress of the administration. It's not unusual for me to hear from clients who are in those positions that they've spent hundreds of hours on estate and trust administration matters. If you were nominated to serve as personal representative or trustee of the will, and you agreed to do so at the time that your friend or family member was creating their estate plan, that doesn't mean that you have to accept that role when the time comes. Maybe when you agreed to serve, your life was very different than it is now. Maybe now you have a job that requires that you travel, or you have young children that require your attention, or an elderly or ill family member that you're caring for. If you don't think you'll be able to devote the time and energy to settling an estate or administering the trust, then you should decline to do so. Because with that responsibility, once you accept, means that you have a duty to the beneficiaries to carry out those tasks timely and efficiently. And if you don't do that, you could be personally liable to those beneficiaries for lost money or other damages that could arise out of your failure to timely carry out the tasks. So remember, being named as a personal representative or a trustee is a voluntary role. To serve or not to serve is up to you. It's not like jury duty. You can just say no. And you're doing the beneficiaries a favor to say no if you are not able to carry out those tasks. If you have questions about serving in a role as a fiduciary or other estate planning or settlement matters that we can help you with, please don't hesitate to reach out. We'd love it if you hit that subscribe button and that like button before you head out today. And we look forward to seeing you here in this space next week.